Welcome to the Development of Victimology. This is our first module in victimology. This is a course that's brought to you by the International Association of Trauma Professionals, and my name is Harry Morgan. And we're going to be covering a number of things in this course. The first thing that we're going to be covering are the definitions and terms, and then we're going to be looking at the historical development of victimology and the victims movement, and then finally we're going to be discriminating between the victim precipitation and victim blaming. And so looking at, well, what is a victim? Well, it comes from the Latin word victima, that means a person or an animal that's killed as a sacrifice. And that's combined with the Greek word logos, from which we get our English word logic, and it's typically translated word, and it infers science or a system of understanding or knowledge. As we look at the history of understanding victimology, although the term isn't used until the 1900s, we find it way back 2000 BC. And that is that it refers to an animal or a human sacrifice. And then in the 1650s, it was used of a person who is hurt, tortured, or killed by another person. And then in the 1718, it was used of a person that was oppressed by some power or situation. And then in the 1780s, thanks to William Blackstone and his importance of emphasizing the victim, it's referring to a person that's taking advantage of someone that's weaker than themselves. And so now we look at Black's Law Dictionary, which is the dictionary commonly used by attorneys in defining the terms of law. And the word victim means a person that's harmed by a crime, tort, or other wrongs. It also, Saparovic is a Croatian expert in the area of victimology. He defines victims are persons that are threatened, injured, or destroyed by an act or omission of another man or structure, organization, or institution. I'm going to give you a number of definitions, as you'll see. Some of them are repetitive, but I'm also citing the agencies or organizations that are giving us the definition. So as the United Nations Declaration in 1985, victims mean persons who individually or collectively have suffered harm, including physical or mental injury, emotional suffering, economic loss, or substantial impairment of their fundamental rights through acts of omission that are in violation of criminal laws operative with member states, including those laws prescribing criminal abuse of power. The common definition that is used in Daigle and has written a number of textbooks. She's been doing this for at least the last 20 years, along with Moftik. Writes, victimology is the study of the etiology or causes of victimization, its consequences, how the criminal justice system accommodates and assists victims, and how other elements of society, such as the media, deal with crime victims. Victimology is a science. Victimologists use the scientific method to answer questions about victims. That's really an important point, because one of the things that's a struggle, especially in early studies of victimology, is it a science or is it a human rights where it's a social movement, and which do we emphasize?
It's 11 hours.
Schneider emphasizes the science of the victim of the crime and emphasizes the association, particularly with the abuser. I use Tilburg here because Tilburg is one of the two major international universities, this one in Netherlands, that gives us an excellent definition, and I wanted to highlight some of the key words that are used. Notice the word extent, nature, consequences, causes, and reactions. And so that really helps us as you're reading through that definition. And then we move on to Kirchhoff that says victimology is in the past and in the present come from different academic or professional backgrounds, from sociology, from law, from psychiatry, psychology, social work, and management. In other words, it's not just from criminology, it's also now wide. It has many different circles or spheres that's impacting and influencing our understanding of the victim and victimology. The scope of the contemporary victimology extends beyond criminal law and criminology into other disciplines: medicine, engineering, geology, ecology, biology, and geophysics, believe it or not. So that it's really encompassing the entire environment of the human person. And then we have defense attorneys who actually were very much involved, as we'll see later on, in the development of victimology. They talk about the rights and the protection of the offender. So as we see victimology oftentimes as a subset of criminology, the emphasis is on protecting the criminal, and it's criminal oriented. We come to victimology. This is victim oriented, but the two will get quite enmeshed in the beginning. We now go, as we begin our study of the history, we go back to what we call primitive law, which is really referring to the law before there was any codified or written established rules. It's a system of rules that are used by the pre-literate societies to govern a tribe, client, a gathering of individuals, and they incorporate three major premises. First of all, acts that injured others were considered private wrongs. It was between these two parties. It wasn't including the government or the state that was governing these parties involved. The injured party was entitled to take action against the wrongdoer, so there was some kind of reciprocation or retaliation. And then this action usually mounted to an in-kind retaliation, which, as we go to the next slide, we'll see now how that really plays out. Because we have what's called lex talionis, and that is literally translated eye for an eye. It's the basis for what we see in ancient Sumer or Babylon, and it was the restorative relationship between the victim and the abuser. These are just some samples that you find in Hammurabi's law, that it was really for the limitation of that retaliation, so that if an individual poked another's eye out, maybe by mistake, or maybe they got into a fight and thereby he lost an eye, well, the law was to limit the effect of retaliation so that you couldn't punch out two eyes, you couldn't take his life, you could only have the punishment equal to the crime. So that was really important 4,000 years ago. That is carried on then into the penal code that we see in Hammurabi, listing the acts that were included that were considered criminal, a section that is containing instructions for judges, police officers, law enforcement. And then there's another section of Hammurabi's code that's on the right in the duties of husbands and familial type things. And then there's a regulation of wages, so it deals with employment. And all of that, interestingly, 4,000 years ago in this Sumerian document. And then there is the ethical code for merchants and doctors, so the business world is also incorporated. And this would be then affecting the victim, which could be of each one of those four different areas. We then come to what we call Torah, or the law that was given by God to Moses, commonly known as the Decalogue, literally meaning the Ten Commandments. And these were laws that governed dietary, social, criminal, and worship. It was far more than just simply the Ten Commandments, actually. It's commonly those books of Genesis, Exodus, Leviticus, Numbers, and Deuteronomy. And we'll see that, for instance, in Deuteronomy 19, and that's verse 1. There aren't 191 chapters in Deuteronomy, but you'll find the cities of refuge. Actually, this was for one who had been, let's say, accidentally had killed a person, and thereby would have been esteemed to be an abuser that had taken a life, and using Hammurabi's code, they then would be subject to having their own life taken. But they're innocent. They're a victim. It may have been an accidental, and so consequently, there were these 7 cities of refuge that the person could go to until the facts could be sorted out. And then we find the word victim itself is used in the Tanakh, commonly known as the Old Testament, and that's used 14 times. But the word innocent, interestingly, is found 175 times in the Decalogue. So that's really, really important to understand. And then we come to Roman law. Now, Roman law is about, we're looking at the period 450 BCE, and that is where Rome, when the plebeians rebelled against the those that were the ruling class, they wanted 12 laws that were established. They were put on wooden tables. They were displayed in the forum that you see on the left of your screen. And they were the basic rules that would govern really everything, just from family to the religious life, economic life. It would help to guide then what would be the, I would say, the blue class workers and the white class workers together. And so they were commonly working by the same rules. We then find that Roman law actually extended over the entire Roman Empire. It even affected eventually England. And we're seeing this actually again before the time of Christ. We're looking at England was conquered by the Roman legions in the first century. And then we see this Roman law. It's brought in that governs now certain guidelines for, again, it could be family, it could be economics, it could be virtually everything. And it gave a basis for defining who was the victim of a crime. And then we come to Justinian the First. This is really important. We're looking now at a little over 500 years after Christ. And Justinian is known as the one that codified Roman laws into a set of writings. Up till that time, they were commonly known as the 12 tablets. Now they are becoming law. And there are 2 types of losses a victim could experience, and they are public and they are private. It begins now the difference between criminal and civil laws that we have in the United States. Then we find in the Middle Ages that we go through 4 different aspects of law. In the beginning, the burden of the justice system was placed on the victim. The victim was the one that had to come forth, had to report the crime, was the one that would be the executioner of the sentence. And then you have the lex talionis. That was the justice system that we saw again back with Hammurabi, also with Moses, and that was the limitation of that retaliation. And then we see the retribution. The criminal was punished because he or she deserved it, as it was esteemed by some type of tribal or communal government. And again, the victim was the one that would do the execution, and then the criminal was expected to pay back the victim, and that was in what was called restitution. And so that was all in that period of time. Then we come to the Normandy invasion, when William the Conqueror now conquers from France, moves into England, brings then a centralized form of law. Up till that time, England was very decentralized. We there weren't any real codified laws, and thereby victims could be easily abused, and oftentimes justice was not served. But here we find with the Normandy invasion, the crown of England is established. William the Conqueror is now the King of England, and he codifies laws and establishes a system whereby crime could be defined and the criminal could be identified, and the victim could also be identified, and justice would be served to the victim. And then we see William the Conqueror. He established royal administrators, and that was commonly known as the Cura Regis, which is literally translated the King's Council. This King's Council was made up of lords. They would be even priests. They would be sometimes attorneys, and they would be together forming a circuit court. The circuit, because they would move from village to village as actually a team. It may be 3 or 4 of these individuals, and they would be the royal judges, and that would provide then some adjudication of law, but also some kind of protection for the victim. This was separated from what had preceded, which was the church law. Remember, the Holy Roman Empire was very much in control of this period of time, and so we have Rome controlling the courts, and now we have the separation of the ecclesiastical or church courts from what now is the Cura Regis, the King's Court. And then we have what we find English common law. And English common law is around the year 1200, and this is what's called common law. And it is what was commonly known. It was stare decisis, which means to stand by its own decided law, a system for deciding the outcome of cases, developed by a court system during the Middle Ages in England. And cases were heard, judges would deliberate, and a decision based closely on previous court cases would then determine the outcome. This was really, really important because, as we see, this is the beginning of what we understand in American law, what we call case law. A prior case sets precedent to be determining the current outcome of the case being reviewed. And then what we have is the Magna Carta. And the Magna Carta it was called the Magna Carta because actually there was a prior Carta. There was a prior conclusion or a prior statement. Magna means large. There was a smaller one. The smaller one initially was Edward. Edward was a rather lame king, and those who were the lords wanted to establish their rights, and that saw him as not a consistent, rather capricious potentate, and so consequently they established that. That worked for a while, and then we had other kings. Edward was killed, other kings come along, and now under King John, it's established in 1215 by these lords, different set of lords, of course, that we have the establishing of individual rights. It was actually more the lord's rights than the individual commoner, but still in all, throughout history that gets debated. It is still very, very important because that becomes the foundation of our American experiment in democracy, the establishment and the elevation of individual rights. We see that actually in the U.S. Constitution. We establish individual rights. The Constitution, as we have the 3 articles, establish the 3 various parts of government, but it's the Bill of Rights that really emphasize then the individual rights. We have statutory laws, and they are the ones that are governed by state legislators and Congress, and they're compiled into various codes, and they're subject to revision by legislature. That's what we're often referring to if you're a clinician or you're in law enforcement and you're working with a particular statute. That's what you're looking at, not constitutional law frequently. And then there's administrative laws. The administrative law is actually a subset of the statutory laws. They are the actual implementation of the laws that are the statutory. So that the way I've outlined it is that you have the U.S. Constitution is the foundation. Statutory laws come out of the Constitution as they apply to given circumstances, and then the administration is the execution or the regulations to be applying the statutory laws. I'm giving you here just a list. As we look at victimology and its history, we can find that it starts very early on in 1764 with the Italian Barricata, and then Lombroso. You go right on through to various ones. It's really not until Mendelssohn that you have in 1937 the term victimology used, but there are writings before that. You have poets and writers that are also, we'll look at in our next module, that will help to popularize this concept of victimology, but in academic circles and usually among criminologists. Many of these writers that you're looking at are criminologists. And then we find that the movement makes some changes because it moves now, and we're looking at the 60s, 1960s, that it's moving out of the academic circles. It's more than just simply the talk of criminologists and writers. It now is moving into an activist movement. And so we have the feminist movement that is emphasizing that women are victims. They're victims in the workplace. They're victims in terms of employment. They're victims in their homes, perhaps. They're victims in society in general and how they're treated. That moves us also into civil rights laws and various minorities that also are not treated fairly. And so that changes the whole social attitudes toward crime and toward victims. And then we have the victim rights movement, which is actually in the 1970s and on. So it's a rather recent phenomena as we would look at this. And then we find, as I was reviewing the feminist movement, please notice that that doesn't start in the 1920s, as we often think that it starts with Susan B. Anthony. Instead, we find in the 1880s, married women were given the right to exercise fully independent legal capacity, and then they gain access to government and to administrative positions. And then in 1913, we have the right to vote with the 21st Amendment, and then in 1927, women are placed in an equal footing with men, and they now have not only the right to vote, but now women are taking more and more place in the workplace, and they're having responsibilities for even owning property and other things that I know it's hard for us to imagine, but women did not have those rights in the 1800s. And then they have full rights to serve in other capacities. We look at the criminal justice system and how that's changed in its view and how social attitudes change the criminal justice system. When victims do report and enter into the justice system, they're now viewed as witnesses rather than victims. We've had a great shift that's taken place in the 1900s. We went from a victim-focused view in victimology to now it is the state that is the victim. So, for instance, you'll see that in today's court, if you're a victim of a crime, you go to court, your name isn't registered. Instead, it is so-and-so that is the perpetrator versus the state that you are from. And you now are simply a witness. And the justice system then comes in, the law enforcement comes in and asks you, the victim, what you saw, when it happened, how it happened, and what your part in it, so that now you become even a suspect. And so therefore, victims are not always treated with dignity and respect. And victims now have to deal with the police. And so oftentimes they are re-victimized. And there's a secondary victimization. And some victims have now a fear that they're going to be disbelieved, because in fact, very frequently, and in rape cases, that is the case. And so they, as a result, don't report. That changes now more and more as we get into the 1980s. When Ronald Reagan becomes the president, society as a whole becomes more conservative and therefore more concerned about law enforcement, about crime, and thereby the victims' rights movement. And so he has a task force that's formed, and they release a report in 1982, and it contains a number of recommendations which are implemented in the 1980s and 90s and later. And now we have the establishment of an office for victims' crime, and the Victims' Crime Fund is also now established. Victims have resources that they can go to and ways of reporting to make it more accessible to them. And now we see also society becomes more aware of trauma. And of course, that's why we have the International Trauma Association, because we realize how when we're a victim, that affects our brains, that affects us with PTSD, that affects us psychologically. It affects us in terms of our socialization. It affects also those that are tangential to the actual victimization, and they too are victimized, such as you may not have been in downtown New York City on 9/11, but if you watched over and over and over again the events of 9/11, then you have also been traumatized. The media was used to increase the public awareness in the 1980s, and the victims' crime movement grew out of dissatisfaction of victims with a passive role, neglect and minimization of harm that they often suffered. So there was an attempt to elevate that. I wanted to emphasize that word, secondary victimization, and that is not caused by the actual criminal event, but instead by oftentimes law enforcement, or it could be even in mental health, where we're not sensitive to the victim, and thereby the way in which we are approaching this, we can be re-victimizing the individual. This is especially true when working with children that have been victimized, and at the number of times that a child is asked to repeat their victimization, they can have that secondary victimization. We look at the victims' rights timeline, and so we're looking in 1990s, and we see in the mid-90s that studies begin to examine how the victim contributed to their own victimization. Notice we have the victim blame here, and the reason for that is much of the research and the writing during this period of time is written by criminologists, it's written by attorneys, it's written by people who are themselves looking at crime and criminals, and thereby seeing the association with the victim and believing then that that's appropriate. In the 1960s, we have the first victim compensation program, and it starts at the University of California and in California. And we find that that now starts to move it away from the blaming of the victim now to the greater sensitivity to the victim. And then in the 1970s, we find the homicide survivors developed. We find families and friends of missing persons was organized. We find in 1978, the parents of murdered children is also formed. A number of organizations and associations like that. We find, again, this is very much similar to the prior. I'm just emphasizing how this actually plays out with the women's rights movement. And that is in the 60s, we find the civil rights and the women's rights movement really elevating how these rights, these minority groups or women have been unjustly treated, or how they've been minimized, overlooked, and thereby really elevating this whole area of victim rights. And then also identifying children as another area where there has been a minimization. And then finally, we find actual activation. We find groups that are started, such as MAD, Mothers Against Drunk Driving, and we find other agencies that are formed that act on what we had discovered in elevating and researching this field. We then find the World Society of Victimization. That's actually begun in Israel in 1973, the first international symposium on victimology by Israel Drapkin. And that moves then to Boston in 1976. Again, the same thing, but it's not formed as an organization until 1979 by Schneider and other, but please notice, criminologists. We still see victimology as a subset of criminology, and the victim, even now in the criminal justice system, is seen not as the focus as much as a witness and producing evidence as to the crime, and the one who receives the payment or the settlement or whatever oftentimes is then the state. We find in just a timeline, we look and you can see 1965 you have the victims' rights laws passed, and then NOVA, and then the World Society of Victimization. The United Nations takes action, and so forth. I'm going to go in a little more detail later on this, but that gives you an idea where we're just seeing that this idea of victimization, victimology, is a rather recent thing in focusing on it. Yes, it goes back 4,000 years where there was a focus on victimology, and there was some discussion about it, but not to the degree that we have now. The emergence, and I'm just going to cite some key works here. The term victimology first appears in a book that is written by Frederick Wertham, and he's a forensic psychologist, 1949. And then we find that today victimology is referred generally to a scientific study of victims and victimology, including the relationship between victims and the offenders, investigators, courts, corrections, media, and social movements. So it's much broader than just simply looking at who's the perpetrator and who is the victim. Now I'm going to give you some dates and go through this rather quickly, but I want to show you just how this develops. We have Erwin Sutherland, a Dutchman who includes a chapter on victimology in his criminology textbook. Please notice criminology. Mendelssohn is he's a Jewish attorney, publishes in his writings on the rapist and the victim. And again, it's looked at as a emphasis on criminology. Von Hentig Dutchman, again, an attorney, publishes an article entitled "The Victim and Criminal Interactions" in a Dutch publication. And then 1947, it's Mendelssohn that actually coins the term victimology. First time it's used in a French journal. For that reason, he's called the father of modern victimology. And then in 1949, you find Wertham, and he uses the term victimology in his book, The Show of Violence. And you have Fry in 1957, proposes victim compensation in the London Times. And then in 1958, Wolfgang studies homicide victims, and we find the first time the term victim precipitation. We'll look at that in a future module. And then in 1963, New Zealand enacts the first Criminal Compensation Act. I'm going through this because I think you'll see this is global. This isn't something that's just the United States, not in one state. It's literally the whole world is now more and more conscious of the needs to address victimization. 1965, California is the first state in the U.S. to start victim compensation. 1966, we find Japan enacts the first criminal indemnity law. 1966, the U.S. began surveying criminal victims not reported to police. 67, we have Canada that created a Criminal Compensation Injuries Act. So does Cuba and Switzerland. And then Schaefer writes his first victimology textbook. It's 1968, The Victim and His Criminal. And then the first International Symposium of Victimology is held in Jerusalem, as I had pointed out before, but it's really important to see where now we're bringing together victimologists, not criminologists, that are coming together to talk about human rights and the suffering that is happening around the world and how the victims are not being treated appropriately. The first police-based victim advocate project is started here in Florida. That's because I'm in Florida. And then the first Victims' Rights Week was organized by a Philadelphia district attorney. And then in 1976, we have the launching of the National Organization for Victim Assistance, NOVA. 1976, we have Emilio Vigliana, who launched the first scholarly journal on victimology, which still is in print, still circulated. And then in 76, we have Rowland that creates the first victim impact statement in California. 1979, the World Society of Victimology was founded in Munster, Germany. And then Ronald Reagan, as I pointed out earlier, proclaims the first National Victims' Rights Week in April, which is every April. 82, the first Victim Impact Panel is established, and it's established by Mad Mothers Against Drunk Drivers. 84, the Victims of Crime Act is established. 85, the United Nations unanimously adopt the Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power. And then in 1990, California passed the first stalking laws. 92, the Family Violence and Prevention Act. 96, the National Domestic Violence Hotline is established, Megan's Law. 97, Victims' Rights Clarification Act. There's a result of the Murrah building in Oklahoma. And then 98, the Crime Victims with Disabilities Act. 2000, Victims of Trafficking and Violent Prevention Act. 2001, Special Federal Victim Compensation as a result of 9/11. 2002, the International Criminal Court created the Victim Aid Witness Unit. And then they have the Amber Alert, 2003. And then the Tokyo International Victimology Institute. This is the first international institute, very, very significant. They have that now every 3 years. That's important to check into if you haven't been familiar with it already. Then 2005, Japan puts on the United Nations Basic Principles of Justice for Victims of Crime and Abuse of Power in their national legislation. 2006, the Adam Walsh Child Protection and Safety Act. 2007, the Crime Victims' Rights Rule Act. 2008, the Trafficking Victim Protection. And then 2012, this is the other one besides Japan, the one in Netherlands, the Tilburg University. You can get a master's degree in victimology. The one at Tokiwa University in Japan, you can get a PhD in victimology. Both of those, if you go on their sites, you'll find just a treasure trove of information that'll be helpful to you. And then in just January of this year, 2017, we have the enforcement of federal law with respect to transnational criminal organizations preventing international trafficking. That was established by President Trump, which actually elaborates further what President Obama had done previously. And now we come to our discussion question. This was a lot of information, I understand. However, if you'll go back over it, you'll find that these names and so forth will be more and more prominent to you. And that is your question that you need to post an answer to is explain the evolution of the victim justice system to a criminal justice system. Why did this change occur? Do you believe this change is good for the victim, and why? So I hope that you found this to be beneficial to you. In our next module, we'll be looking at forensic victimology. In the meantime, I look forward to seeing you again.